Hello, everyone. My name is Teresa Rickard, and on behalf of all of us at Jones and Roth, I want to welcome you to today's healthcare webinar, 2022 Employment Law Updates. Today, we have the privilege of hearing from attorney Jaclyn Rudebeck and Ed Earl, JD candidate and clerk at Watkinson Laird Rubenstein. We have a very full agenda planned for today, and so Jaclyn and Ed are going to walk us through the latest federal and state updates in employment law legislation and a number of topics that I know are on everyone's mind right now. And then we'll have some time for a Q&A at the end. So please feel free to go into the GoToWebinar control panel and submit your questions. I also want to mention that a PDF of today's slides is available for you to download in the handouts section. All right, let's move on to the next slide, and I'll just tell you a quick little introduction to our healthcare practice advisors here at Jones and Roth. Our practice success plan provides year-round value to practice owners and administrators, helping them to manage their operational and financial performance. We also support the personal success of practice owners through an integrated tax, retirement, and financial management plan. I want to thank our generous webinar sponsor, Watkinson Laird Rubenstein, who provide a broad range of legal services to healthcare practices. With expert knowledge of the complex regulatory environment, their healthcare attorneys help navigate the challenges of operating a healthcare practice. So thank you, WLR. And I'd like to introduce our speakers for today. Jaclyn Rudebeck is an experienced employment and business attorney at Watkinson Laird Rubenstein, and Ed Earl is a JD candidate and clerk there as well. Jaclyn and Ed, thank you so much for joining us today.
All right, sound check. Can you hear and see us?
Yes, fantastic. Thank you for being here. Take it away.
Thank you. I want to first start by just acknowledging and appreciating our colleagues and friends at Jones and Roth for giving us this opportunity to speak to you all today. And I appreciate each of the attendees for making time to join us for this conversation. So before we launch into our very full agenda, just a little bit of additional background on me. This is actually my second stint as a shareholder with this firm. I was a shareholder at Watkinson Laird about a decade ago, and then I took a little walkabout and spent some time in in-house roles in a couple of large organizations here in the Eugene area. And the only reason I want to share that is so that the audience, the attendees on our call today know that in addition to being an employment lawyer and helping our clients navigate compliance with all the various requirements that you're subject to, I have also spent a lot of time in the trenches being responsible within an organization for figuring out how the heck are we going to implement this stuff. So I've been there, I feel your pain, and we're gonna get through it together. So that's just a little bit more background on me. And I also wanna introduce my co-presenter, Ed, has been clerking with our firm since January of this year as a law student. And we love to give our law clerks the opportunity to learn and grow in these ways and to join us for presentations along these lines. And he has done an incredible amount of research in preparing for this conversation today. So we're pretty excited to share all this information with you. But first, I have two things. I've got a disclaimer, of course, because anytime a lawyer gives a presentation, we've got to start with a disclaimer. So I need to make it very clear to everybody that the fact that I'm giving this information today, it's not intended as specific legal advice to any person on this call. And this conversation that we're going to have does not create an attorney-client relationship between each of you as attendees and with our firm. All right, disclaimer out of the way. Now we're going to see if we can navigate technology. I am going to launch a poll question for each of you, and I hope that each of you could take just a moment to respond to the question. So it's really going to help shape our approach to the conversation today. So I'm going to launch this poll question. Very simple, 2 options.
Oh, we're over halfway.
All right, crushing it. All right, we'll give it just another 5 seconds or so for our stragglers to answer this question. The reason this is important is because, as with almost all employment laws, some of the stuff that we're going to talk about today varies in applicability depending on how many employees we're talking about within the organization. Okay, so I am going to go ahead and close our poll in 5, 4, 3, 2, 1. And then we're going to look at the results. Okay, so we've got just over half of our participants said that you're part of an organization with 25 or more employees, and under half are with fewer than 25 employees. So thank you for giving us that information. Okay, so back to our agenda for today. We are going to spend some time diving into the new Oregon Paid Leave Act. We're going to talk about some new physician-assisted rules. We're going to talk about the various federal and states of emergency, the status of them, and why we care. And we're going to talk about Oregon's pay equity laws and specifically how that relates to recruitment and retention of employees in the landscape that we're all operating within right now. And then I'm going to, if we have time, I'm going to run through a couple of other recent state and federal employment law updates that we all need to be aware of. So with that, I am going to see if I can close that. All right. With that, I'm going to turn it over to Ed to talk to us about, oops, there we go. Paid Leave Oregon. Take it away.
Okay, so Paid Leave Oregon, which was passed a few years ago, but is starting to be implemented this year and the next year when it really goes live, is a really ambitious program to create what was originally called the Paid Family Medical Leave Insurance Act, and now has been dubbed by the state simply Paid Leave Oregon. So you can find all the information about it on the website at paidleave.oregon.gov. So why is this an ambitious program? This is both a leave program like the OFLA or FMLA, but it is also an insurance program. So it's actually similar in some ways to things like unemployment insurance or workers' compensation insurance. It's not just that your employees can take leave, it's that your employees can then file with the state a claim to get benefits while they are on that leave. And so this is a big distinction between the previous leave programs, which are generally unpaid, and so people would have to take PTO, vacation, or sick leave. This is a separate program run like an insurance program for which they can file claims with the state and get a weekly benefit amount. So who does this cover? This covers anyone with an employee in Oregon. It is really a wide-ranging, meant to cover everybody possible. The few exceptions are tribal governments can opt in but aren't forced to join. The federal government does not count and cannot join. And independent contractors, even if they aren't employees, can actually join themselves and opt into the program. You also have a few exceptions for things like domestic service, teenage babysitters, if you hire your own kid and they're below 26. There are some really small exceptions there, but the goal is to create a large program covering almost every employee in Oregon. So on the details, it can give up to 12 weeks of paid benefits a year to your employee if they're on leave. It actually can give an additional 2 weeks if that leave is related to a pregnancy, for a grand total of 14 weeks of paid leave per year for an employee if they meet the qualifying conditions. And so that's one of the big questions I want to cover is what are those qualifying conditions? And so you have three general categories, which is medical, family, and safe. So medical leave, this is not for a common cold. This is for what the law calls serious medical conditions. And that means imminent death, terminal diagnosis with death in the near future. It requires constant care, or it's inpatient, it's related to pregnancy, or it's for the donation of tissue or body parts. So inpatient is something that makes a lot of sense, requiring constant care, but this is not going to be simply every time your employee takes a sick day, they'll be able to file for leave. And for the medical professionals, you might actually anticipate getting some questions from folks who want documentation to get this leave. So you're playing another role in this beyond just that as an employer. When it comes to family leave, what that means is you get time to bond with a child, and that is either in the first year after they're born or in the first year after they were either adopted or placed in foster care. The other part of family leave is you are allowed to take leave and file for benefits if your family member has a serious medical condition, the same serious medical conditions we just talked about. So you can take leave to care for them. Safe leave is probably the most complicated one, but is a really great addition. And this is for victims of domestic violence, sexual assault, stalking, or harassment. And what it does is it gives them time off to work with security, go to court, relocation assistance, seek counseling, or talk to law enforcement. So those are your three big buckets for which any employee can get leave if they meet a qualifying, like they have a qualifying event. So this applies to anyone with an employee in Oregon. As we talked about, it's protected, which means if your employee leaves, you need to reinstate them to the same position when they return. If that position isn't available, you need to return them to a position that has the same terms and conditions of employment. There is a caveat, as we said, for smaller employers. So we'll get to that because there are a few things small employers don't have to do that everyone else does. One of the other really big notes for this as a leave program is you can take it intermittently, which means that your employees can take it one day at a time and then file for leave. So it's not like, if you're familiar with the FMLA, the Federal Family Medical Leave Act, they take a chunk of time off. This is very much, they can do a day at a time as necessary for their qualifying condition. And employees can apply to the state 30 days before or up to 30 days after their leave event. So there's a window in which they take leave that they have to actually let the state know and file that claim. So numbers wise, what does this mean for you as an employer, or if you're an employee, what does this mean to your paycheck? So the state each year sets a rate, and this rate for this year is 1% of payroll for any employee up to that, what you pay that employee, $132,000 essentially. And so for every paycheck, you have to take out 1%, and the employee pays 60% of that. And the employer contributes 40% of that 1% of payroll. Interesting note, compared to things like unemployment or workers' comp, there is just one rate for the whole state. So your claims history does not change what you would end up paying into this program. If none of your employees take any leave, you're still paying the same as an employer who has all their employees taking leave. And then the state will be setting that rate once a year in November for kind of a rough guesstimate of what this means to an individual paycheck. Say if you were making $150,000 a year, you yourself would end up paying in a little less than $800, $797, because that is your 60% of 132,000, because that's where it stops. So if you make anything above that, nothing is taken out. Your employer would put in about $530. So it's really not a lot, but it does just add up over time. There will be a few things about when these are due. So your payments are due quarterly, or as we have led you to believe, small employers have some differences. And so small employers can actually pay annually. And so that'll be quarterly. It's on the Oregon quarterly tax report. Annually, there's an Oregon annual report where you will give the state all the information, make your payment, and then do it again the next year. So because this is based on the amount of wages, so that's 1% of the wages you're paying to any given employee, $132,000 a year. What matters is what count as wages, what don't. And so here, it's pretty much what you'd expect, but I think it's important to go through what counts. So bonuses, fees and prizes are all wages, tips are wages, any type of sick pay or PTO you provide your employee are wages. If you serve as a director or officer of a corporation, then those can be considered wages if they're given for services. But certain things are not wages, and so you don't need to keep track of them. And so if you're working late at the office and buy food for your employees, that doesn't count. Reimbursed travel expenses for gas or hotels don't count against that. Pensions, jury pay, gifts, if you get them from not your employer. So if you give something to your employee, that counts. If a customer gives something to your employer, or a patient in this case, that does not count. And if you run a cafeteria plan program, neither does that. Oh, actually, I'm just going to go back for 1 second because I forgot to mention this. This only, when it says $132,000, that's not the net of that employee over the year. That is only from that employer. So if someone works for 2 different employers, it is still 132 for each one of them. So there's no communication if, say, you have an employee who works other places. Don't pay attention to that. Just look at their payroll with you. That's the only thing that you need to care about. So what is it with small employers? So if you have fewer than 25, the big difference is that you don't have to pay the employer share. So that's that 40% of the 1% rate. So your employees still have to pay in theirs, but you don't have to. And so this is the state recognized that a small business, you probably have less margin, or simply you need a little more flexibility. As we mentioned, you can pay annually instead of quarterly. And here's a really interesting part of this program is even though you don't have to pay, you can. And if you choose to pay in your 40% as a small employer, you get access to grants that you can apply to the state for if you have an employee who takes leave. And so these are grants that can go either $1,000 grants for overtime and other expenses. So if your employee goes out and you have to pay your other employees more money, the state can end up reimbursing you a little bit of that. And there is a $3,000 grant that you can get for hiring a temporary worker. And so a temporary worker could come in, replace your employee on leave, and you would get the state to give you $3,000 to cover some of that. The real, I don't want to say it's a downside, but there's a condition to getting those grants, which is if you get a grant, you have to agree to continue paying your elective 40% share as a small employer for the next 8 quarters, so 2 more years. So if you want to do the grant program, and another limit is you only get 1 grant per employee, and it's up to $30,000 per year per employer. So if you have a lot of employees doing this, you can end up getting maxed out on your state stuff. The other part of this is there's an exception to protected leave for small employers, and that is if the position that the employee left when they went on leave is no longer around, you got rid of it, you do not have to bring them back to an equivalent position. You still may choose to do so, but if their position is eliminated, it's at your discretion, where with a large employer, even if you eliminate the position, you will have to bring that employee back and find them something that has the same terms and conditions. And as the state has put in one of their examples, the terms and conditions do need to be very similar, because their example is a delivery driver who has to be put back on the same route and has to be put back on the same shift. And so you're not just coming, oh, we're going to pay her the same amount of money. You really need to be looking at all those little details to not get a complaint. Next up, we have how we determine employer size.
Sorry, we're just, I'm glad that we're getting a lot of questions coming in. I think we are going to save them to the end, Teresa, but thanks for letting us know. I'm glad that our audience is engaged in sending us questions.
So a big question that everyone will have, and maybe you've even already asked, is how do you determine employer size? If this is so important to the program, how do you do it? And it's done based on the average of the 4 calendar quarters. So if you are filing quarterly, the state will notify you by November 15th saying what your size is for the next year. And then you're locked into that. And if you file annually, as we said, you're going to be filing in January, the state's not going to know. So in that case, they're going to let you know by March. So you have a slightly different time frame if you're filing differently. But the state itself goes through your records and determines what your size is based on the average quarterly size. If you don't file anything, you're going to end up as a large employer, even if you have 5 employees. It's really on you to be the one filing. There is very limited reassessment so far. I should probably say this is an evolving program, so there are still a few rules that haven't been finalized that we're waiting on figuring out, but we can imagine that there will be some developments over the next few years as they iron out the kinks of this. The other thing is you do not round your employee count, so it's always going to end up at an exact number. Next up, we have the timeline, which I'm sure you're all worried about because when does this matter? So we'll get to equivalent plans. So this is a little preview of what that means. And that's actually the first thing that's coming up, and those start in September 2022. And that's the state getting ready for the launch of this next January when contributions begin. So starting January 1st, you need to start keeping track of what money you owe the state, both for your employees and if you're a large employer or opt-in, what you need to pay the state. By June 1st, you're going to get a notification of your size because they're going to use the first 2 quarters to figure that out for you. And then the big day everyone's waiting for, September 3rd, 2023, because that's when claim filing actually begins and the rubber meets the road on this whole program. So we're a little over a year away from the first time benefits start rolling out the door, but we're really within a couple months of some of the really big starting points for organizations when it comes to engaging with this program. So an equivalent plan is your ability to opt out of this state plan. So if you don't want to pay your employee portion or your employer portion, either way, you can develop your own thing that is like the state program. And I will say this is very much, it has to be very similar. There are a lot of administrative details for you to check off here. So you're going to have to run appeal processes. You're going to have to, you'll have instead of having the state get the claims from your employees, you're going to have to get the claims from your employees. They might involve medical records and other details that are also private or confidential. So there's a lot of administrative hurdles you're going to want to think about. So that leads me to, there are 2 kinds of equivalent plans. There's one that you administer yourself, and there are equivalent plans that you actually hire a third party to do. So you might even have seen advertisements for this because there are firms that are working on this right now and trying to get the market on that. And if you hire someone else to do it, you're still responsible for everything, but you at least you're responsible, but you don't have to do it. You can put it to a professional HR department because some of these things really require a professional HR department. Under the law, there's about 15 different ways that you need to be the same. You can't require employees to pay more. You can't pay them less. You have to offer all the same amounts of leaves. You can't add any terms or conditions beyond what the state itself has. So this is not about tailoring a program to what really works for you as much as meeting what the state requires you to have. When it comes to equivalent plans, if you have one, you do have to file your quarterly reports, even if you're a small employer, because they want to keep track of what's going on. In the draft rules right now, there's even some more details about this because you have to report to the state under the draft rules whenever you gain an employee or lose an employee within 14 days. And if you gain an employee, you have to keep track of where they're coming from. So you have to contact the state because if the employee is coming from another equivalent plan, then they get to go on your plan on day 1. If they aren't, it's usually a 30-day window. So for an equivalent plan, any new employee has to access it after 30 days. But if they're coming from an employer who had an equivalent plan before, they get it on day 1 from you. So What are some internal things you need to think about? You need to put a procedure in your handbook for how an employee will request leave. And this is for everyone, even if it's not an equivalent plan. Your employee is supposed to give you 30-day notice. So you need to have some type of procedure within your handbook to let employees know how to do that. You should probably come up with something about how are you returning people to the same position? What counts as an equivalent position? These are things you need to think about ahead of time before an employee leaves and you have to scramble when they come back. And like every employment law you might have ever seen, there's a notice that you will probably display in your break room or some other place where people congregate, and the state will provide that and you have to put it up. If you have an equivalent plan, you will also have to develop your own notice explaining all the details of your equivalent plan, which you will also have to display. So why should you be doing any of this? Well, the big scary penalty here is if you fail to file your reports and contributions, you can be penalized up to 1% of your annual payroll. And that's a big number. That's as much as you would be paying in entirely over the year, not just you, but your employees. So the state is authorized to attach liens to your property, whether it's personal or real, and they will come after you. So really, when it comes to filing, you need to be engaging with the state, make sure that your reports are getting filed with all the correct stuff, all the details, as well as making sure your contributions are getting there. Like other leave programs, if you fail to return an employee to a position and it was protected, they can sue you in court and they can get reinstatement and back pay. So you can end up paying them for all the time that they weren't actually working for you, as well as having them back in the office. So you really want to be thinking about what, again, going back to the last slide, how do we make sure we get them back into the position without complaints? Because that's going to be a moment where you could really end up with a lot of liability. And then you have the smaller things. So if you fail to post a notice or any other little minor details, it's what's called an unlawful employment practice. You open yourself up to civil fines. Some of them are as little as $100 per violation. Some of them get up into the thousands. So you just want to be dotting your I's and crossing your T's to make sure that you're not caught off guard, particularly because anything here would be a public record because it's the state coming after you. So this could affect your reputation in the community if you get hit with unlawful employment practice violations. So finally, as an end to paid leave Oregon, we have your action items. So the first thing you want to think about is whether you should be considering an equivalent plan. What does that mean for you? How would that work? Would you do it yourself? Would you go out to a third party? You really need to make sure your payroll system is capable of handling the deductions. You want to make sure you're also, ready for the quarterly tax reports or annual reports, and just keeping track of all these new little data points that you need to be reporting to the state. So money-wise, you need to be ready to submit your employer portion when January rolls around, because that's when they're going to be wanting their money, and you have to have that 40% ready to go. And then your handbook, you need to be putting in, as we said, that 30-day notice, as well as any other changes that you want to get in there to adjust or prepare for this program. So you kind of want to get that done soon, even though the program claims don't start till September 3rd. The earlier you get this done, the better it is for you, particularly as your employees will start asking questions about this. The state is making a really big move when it comes to marketing this program. So I imagine a lot of employees will start asking you very soon if you haven't already gotten questions.
So before we leave that topic completely, I know that there have been a lot of questions that have come in, and we're going to address as many as we can when we get to the Q&A. But the one thing that we want to stress is that this law is still being developed. We are monitoring the rulemaking that's going on as it's happening in real time. So some of what we've shared with you today will likely continue to shift over time. So it's really important to be working with your employment law counsel, staying on top of this as it relates to your business.
Thank you, Jaclyn.
Yeah.
That's a great point. So shifting gears a little bit, some of you may be aware there was a new law passed last year, House Bill 3036, that is updating the relationship that physicians' assistants have with their practices and regular physicians. And so this is a big change And I think for anyone who's a PA, they're excited about this. If you're an MD, you might actually be wondering, what does this mean to me? And so the big topics are less supervision required and there's less liability. Really what we're doing is moving from a supervisory relationship to what the state's calling a collaborative relationship. So collaboration is your big word when it comes to understanding the new PA laws. So what happens? You used to have a practice agreement, which was a document that you and your PA made and you filed with the Oregon Medical Board. Now you have a collaboration agreement. This is something you no longer have to file with the state. You just have to have it on hand for the state to inspect at any time. And what it requires is really this articulated collaboration process. And it doesn't have to be too detailed, but it explains what is the relationship and where do the PAs and the physicians collaborate on topics. So previously, you were looking at mandated chart reviews. You were looking at all sorts of little state requirements about how that collaboration works. At this point, the state is getting out of your way and allowing the PA to practice at the top of their license. So this allows you, the collaboration agreement, to figure out what does that mean for your particular practice. The other big changes here, the PAs can now directly register with OMB for prescribing authority. They no longer have to piggyback on a physician's license. You don't have the chart review requirements, and the PAs were added to the statutes about authorizing care across state lines. So this is really telehealth, and part of the goal here was to, in some ways, equalize what nurse practitioners had that PAs did. PAs were left out of all sorts of statutes, and so one of the parts of this bill, beyond just changing how do you relate to OMB, is making sure that PAs are accounted for in all the other places. Thought I had one more slide on that. But the real things you want to look for are the deadlines. You have until the end of 2023 for your physician's assistants to be updated to a new collaboration agreement over the previous practice agreement. But you may want to be doing that sooner if you're hiring a new one, or if you just simply want to take advantage of the new abilities for your PAs to have less supervision. You can go through and talk to your friendly neighborhood employment lawyer and get yourself a new collaboration agreement drafted that allows your PA to do more to assist your practice and your patients. And I'm going to turn it back to you, Jaclyn.
All right, thanks, Ed. Okay, we're going to shift topics again. So I'm going to go through this really quickly, but we want to talk about the various types of states of emergency at the federal and state level that we have been operating within, operating under since early in 2020. So the federal disaster declaration was renewed several months ago. It was renewed February 22nd of this year, and it does not have an end date. The federal public health emergency was just renewed for the 10th time. It is set to expire 90 days from now, unless it gets renewed again, which we think it probably will. And then finally, our Oregon state of emergency actually expired back in April, effective April 1st of this year. I know that many of you are probably wondering if there's any movement that we're likely to see on the mask mandate in healthcare settings as part of our OSHA requirements that were updated in response to the COVID-19 pandemic. We are not seeing any movement on the mask mandate. We'll continue to monitor that and update our healthcare clients accordingly. So the short version of that is, at the federal level, we are still in a disaster and a public health emergency, and according to the state of Oregon, we're not. Why do we care? So there are a lot of different laws that are triggered or not based on what type of state of emergency we may be within. We just called out a couple of them for purposes of this conversation today. One is telehealth. So the ability of a provider to prescribe medication to a patient they haven't seen physically in person was expanded as a result of the federal public health emergency. There is pending legislation right now that's proposed to keep that in place even after the federal state of emergency ends. So we're monitoring that one closely. But for now, when that federal public health emergency ends, so will the ability to prescribe without seeing a patient in person. Another real quick thing to emphasize is that there is an option during a disaster to get money to your employees that is tax-free to them. If so, this is money that's not going to be included in the employee's gross income if it meets the definition of a qualified disaster relief payment. So that is money that's given to an employee either to reimburse expenses that they occurred or to pay them directly, as long as we can show that these are reasonable and necessary personal expenses, family expenses, funeral expenses maybe. So we've seen a lot of employers that have taken advantage of this kind of carve out in the code to give their employees some amount of compensation related to the COVID-19 disaster. Please reach out to your CPA or to our office if you have questions about how to use that mechanism. Okay, now I want to talk about Oregon's Equal Pay Act. And as a reminder, I'm just going to do a brief overview of what that law is. So this is a 5-year-old law. It's been on the books in Oregon since 2017. And the gist of the law is that so the intent behind it is to require that individuals doing work of comparable character for an employer should be paid the same. The intent behind it was to reduce or eliminate disparities based on people that are doing the same work, but maybe they're in a different protected class. So how do we analyze this? First, we want to look at that definition of comparable character. This is really looking at the nature of the work that someone's doing, the skills that it requires, the knowledge, the effort, responsibility, their working conditions. It is not job title. It is not job description. What they're really focused on here is what is the actual work that you're doing? What is your day-to-day, and how does that compare to other people within the organization? So again, the intent behind this is people doing work of comparable character make the same. This law applies to all employers in Oregon. If you have one employee, this applies to you. It also applies to all employees performing work in Oregon. So even if the company, the entity is based elsewhere, if they have employees working in Oregon, this law applies to them. One of the additional factors that this law included was a prohibition on asking candidates about their salary history. We'll talk more about that in a second, but it used to be fairly common on an application or a questionnaire to ask something related to salary history, and now we need to be really careful about how we're having that conversation. What is included in the definition of compensation? This is a very broadly defined term. So it's not just talking about your salary or your hourly wage. It's going to loop in any bonuses to which the employee is entitled and the value of their entire benefits package. It doesn't include reimbursements, and we'll talk more about that later. But mileage, things like that, where we're reimbursing an employee for out-of-pocket expenses, that's not going to be included in their compensation package. But the value of their wages and their benefits package is all going to be included. All right. So on what basis can I pay employee A and employee B a different rate if they're doing roughly the same work? Under what circumstances can I pay them differently? You can still do that as long as you have a system. You're going to hear me use the word system a lot here. As long as you have a system and you can justify and demonstrate that the difference in wage is based on one or a combination of these bona fide factors: seniority, merit, there's a squishy word if I ever heard one, quantity or quality of production, workplace location, that's a big one, travel required by the job, education, training, and experience. So there's a lot of room within all of these factors, especially when you start to combine them. But the important thing, your important takeaway here is you need to have a system that is consistent and verifiable, that if someone, whether there's a claim that's filed down the road or if BOLI shows up to do a surprise audit, which they can do, you need to be able to demonstrate that if there's a difference between what employee A and employee B are making and they're doing roughly equivalent work, that is based on a combination of those things, and the degree of distinction is based in a way that logically makes sense here. So if, for example, if you have an employee that you've got two employees and they're both, they're both medical assistants. And one of them is brand new to your organization. Another one has been with you 5 years, but the one that's been with you 5 years makes 20% more than the one that's brand new to your organization. Are there other factors that can justify that degree of distinction? Make sense? Okay. I'm going to go really fast here and we can come back to questions or you can follow up with us later. So I also wanted to call out that if you have something like a shift differential, if you're an organization that operates multiple shifts, shift differentials are, they can be distinguished on the work of comparable character factor. So yes, the work, the position, their job title is the same, but this employee works, 6 to 3 and the other employee works 3 to 11 or whatever it is, you can pay a differential for that other shift. And that's in compliance with this law. So in 2021, mid-pandemic, the Oregon legislature addressed two things and adopted an exemption from the definition of compensation for vaccine incentives, because that's when the vaccine had rolled out and employers were really wanting to incentivize their employees to get vaccinated, but they were worried about how that was going to work within the Equal Pay Act. And also because of the hiring landscape that we've all been operating within, employers made some noise about wanting to be able to offer retention bonuses and hiring bonuses. So right now, both categories of payments are considered exempt from the definition of compensation. What does that mean? So if I have two employees in an equivalent position, or if I've got a vacancy, I can offer my new hire in that position a hiring bonus, and that's not going to require that I offer that same dollar value to all of my current employees. That may make some noise for, employee morale from an employee morale standpoint, but it's not going to get you into hot water when it comes to Oregon pay equity for now. That exemption was extended earlier this year for 180 days after the expiration of our Oregon state of emergency, which, as you'll recall, expired April 1st. So any hiring and retention bonuses paid before September 28th of this year remain exempt from that definition of compensation. Anything that's paid afterwards, even if you agreed to it, so say, for example, you've got a new hire, you enter into an agreement, you offer them a signing bonus, but they're relocating here from out of state, and the signing bonus is not, you weren't planning to pay it until after they come on board later in the year. If you pay it after September 28th, then it is going to be included in the definition of compensation under Oregon pay equity laws. The vaccine incentive exemption does not expire, so only the hiring and retention bonus exemption sunsets. The others do not. All right, moving on. So we've had some questions about Oregon pay equity and various things that you can include in your compensation package to try to retain your awesome employees or to recruit and make your compensation package attractive to candidates. Student loan repayment is an important one here. So if an employer wants to offer student loan repayment, you certainly can do that. And there are a couple of ways that it can be structured, again, that aren't going to trigger any degree of risk under the pay equity rules. But you want to be very thoughtful and intentional about how you're going to do this. So Can you only offer student loan repayment to a certain category of employees? Certainly, as long as you're paying attention to work of comparable character and that list of bona fide factors, right? Things that you also want to make sure that you're putting in place are some sort of written agreement around this. Most of the time what we see is an employer will require someone to work for them for a certain period of time before they become eligible for that benefit. And sometimes, depending on the degree of education benefit that's being offered, the employer will require them to stay for a certain period of time after the payments have been made, or the employee might have to pay them back. So for example, if I give Ed student loan repayment, maybe I require him to sign an agreement saying he's going to stay and work for my firm for 2 years as a condition. And if he leaves before then, which is certainly his right as an at-will employee in Oregon, he's going to have to repay that benefit that the firm offered. Okay, let's see. Just checking my notes here, making sure that I'm not missing anything on there. So yes, you can limit it to certain categories of employees. Relocation allowances, also, if they are done as a reimbursement of expenses, they're not going to be considered included in that definition of compensation. So that's something that we're seeing offered a lot to try to incentivize, especially positions that are challenging to fill. Okay. These laws also contain a safe harbor, so it's a limitation on the types of damages that the employer can be required to pay in the event of a claim or a violation. So if you can show that an equal pay analysis was done by your organization within the past 3 years, then that's going to be what we call an affirmative defense to compensatory and punitive damages in these cases. All right. So I went through that really, really quickly. I had more I wanted to say about it, but in the interest of time, I'm going to move on to a couple other things that I want to call to your attention. And then I want to make sure that we leave a few minutes for questions. So first of all, there are a couple of updates to the Oregon Family Leave Act that were rolled out recently. So these are going to apply to employers with 25 or more employees, which is the majority of folks on this call. So a couple of things. If an employee experiences a break in service, so they separate employment or their hours are reduced so much they're taken off the schedule completely, but they return to service within 180 days or less, their eligibility comes immediately back to their return, based on their return date, rather, excuse me. The eligibility for an employee also shortens in Oregon if we are in a public health emergency, which right now we're not, but earlier this year we were. So typically, in order to become eligible for OFLA protected leave in Oregon, an employee has to have worked 25 hours a week or more for 180 days. During a public health emergency, that period of time shortens to just 30 days. So pretty quickly after coming on your payroll during a public health emergency, people are going to become eligible for OFLA protected leave, which is totally different from paid leave Oregon because we like to make things extra confusing. All right, the other thing that changed is if a person needs to take time off of work because their child's childcare or their school is closed, again, because of a public health emergency, that is now going to be included in that bucket of OFLA leave that we call sick child leave. Typically before, it was just if your kid was sick, you know, and you needed to take time off to stay home with them. Now it also includes if your childcare is not available or their school is closed. All right, so those are the changes to OFLA. If you are an employer that is subject to OFLA, again, you've got 25 employees or more, and you have not yet updated your written OFLA policies in your employee handbook, you should do so to address these changes. We also had a law that was signed in Oregon in June of last year called the Crown Act. This is a law that prohibits discrimination based on protective hairstyles, so things like braids, twists, dreadlocks, things like that. It expands the definition of race to include physical characteristics associated with race, such as hair type, hair texture, specific hairstyles. And so what we need to pay attention to here is if we have a dress code in our place of employment, it can't disproportionately impact members of a protected class. So again, we've been working with our clients to make some handbook updates to address that law. Very recently, EEOC just updated its guidance regarding requiring COVID testing of employees. And now to ask an employee to provide viral test results, the employer has to show that they have a business necessity and that the request for that information is related to the person's job. In a healthcare setting, that's pretty easy to demonstrate, but it's just something that we want to be aware of. Antibody testing, the threshold is even higher. So we want to make sure that we're paying really close attention to the EEOC's position if we're asking our employees to provide proof of negative COVID tests. All right, a couple more really quick things. So heat and wildfire smoke, so updated OSHA guidelines, most of which aren't going to apply to employers that primarily operate indoors, but if you have employees that are operating in the elements, you want to pay really close attention to what's required by our new OSHA rules. Oregon's minimum wage just went up. And as a reminder, minimum wage in Oregon varies depending on the geographic location. And so one of the results that our minimum wage increases can have is it can create compression within your compensation system that, again, you want to be looking at from a pay equity analysis standpoint. And finally, we had some changes in our laws, both at the state and federal level, about some pretty significantly narrowing when arbitration can be used in various types of employment claims. It is much more restricted now. There are very few scenarios where the employer can mandate arbitration of an employment claim. However, the employee can still choose that. And so there may be plenty of circumstances where that is the employee's preferred route. So that's just something to, if you have arbitration clauses in your employment agreements or in your handbook, make sure that you're working with your attorney to pay attention to those and consider whether you need to revise them. Okay, in the remaining time that we have, which I know isn't much, I want to allow Teresa and Sarah to jump in and let us know what questions have come through that we can hopefully answer.
Yes, thank you so much to both of you. You covered a lot of information in a short amount of time, and that's impressive. Impressive, to be honest. So I'm not sure if you do have access to your email, because I did. No, you don't. Okay, I'm gonna go ahead and just try to select a few here and make sure I get to at least everyone who submitted a question. And then I'm happy to forward these on to you if you want to touch base with people afterwards.
I would love that. Yeah.
All right. So let's start with, if an employee works for an employer that has their own plan and doesn't then pay into the fund, but then changes employers and needs leave, is there a waiting period before they can file for leave funds?
So to just rephrase, you have an employee working for an employer and they have an equivalent plan. So that means that person is not paying into the state fund. So then they go to a new employer. They will have access to funds after 30 days. They will be able to file. So basically, the qualifying thing, and I should have said this, but it is like one of those right at the bottom is to qualify to file benefits, an employee, a person in Oregon, needs to make $1,000 in wages in the previous year. So as long as that person made $1,000 in wages in the previous year, they still qualify for that leave program. They just might have the waiting period right at the beginning when they're first hired.
Okay, great.
And keep an eye out for any changes in the law, because there is still the last couple of drafts of rules. So some of those kinks will be ironed out.
Okay, great. Thank you. This is a two-part question. Do we get a refund if our employees do not use this? And the second is, in quotations, we agree to pay for 8 quarters. Is this optional?
No refund.
Yeah.
No, you pay in, and that goes into a trust fund run by the state of Oregon, and they this is the most ambitious leave program in the country. So some people do have concerns about its solvency. So you can just take as a general thing, they do not want to give you your money back. They need to get as many contributions as they can to make this a viable program.
But that is one of the reasons that employers might consider an equivalent plan. They're just going to be balancing the administrative expense and the hurdles that they have to jump through with being able to keep those funds in their own bucket.
Yeah, that any funds that you keep for an equivalent plan, you have to hold in trust, so they can't be mixed with your funds. But when your employee leaves, you still have whatever they paid in. So yeah, you can essentially have your own fund to cover that. So great point, Jaclyn. What was the second part of the question?
It says, we agree to pay for 8 quarters, in quotations, like that's the agreement. And then the question is this optional?
So that's if you apply for a grant and receive a grant from the state, then you do have to agree to pay those next 8 quarters. And if you don't pay the contributions, again, this is a contribution you're required to pay that you're not paying. So you could be liable for up to 1% of payroll if you don't. So,
right?
Yeah, they can come after you. If you file, I mean, this is general stuff, but you file any false paperwork with the state and start telling them, I will do something and not do it, that opens you up to a whole lot of things. And there are recovery actions for grants if you don't use them for the right stuff, if you lied about the reasons, or if there's any funny stuff on your paperwork. So I would strongly recommend that if you agree to pay for 8 more quarters, you should probably pay for those quarters.
Thank you. How about small employers with fewer than 25 employees? Are there reasons why they would choose to pay into the program?
Yeah, I think that's a really interesting question that we've been wrestling with as we prepared for today, because I don't see a lot yet. I think that the state is intending that these grants will incentivize employers that are small to participate, but I don't know that there are a lot of real strong reasons that are hitting our radar so far.
No, yeah, I 100% agree with that, because the grants are helpful, but when you start running your numbers, that's going to really show you how helpful they are compared to you making those contributions for many years, losing the flexibility. And yeah, we're bouncing that one around the office.
Okay, great. Let's see, let's do just a couple more. In the equivalent plan, can the employer agree to pay at least as generous as the state plan without having to track employee contributions?
So if you're doing an equivalent plan, you don't actually have to track employee contributions, because you could, no one's going to do this, just fund it all yourself. The law just says you can't charge your employees more than that. So if you're charging your employees anything, you're going to need to keep track of that, because you have to be able to show to the state that your equivalent plan is not charging them more. So you technically don't have to charge them anything, but you do need to keep track of anything you're charging them, so you have a record to show to the employment department if they come and ask questions.
Okay, great. And kind of on that same note, I have another question that's what factors go into whether a practice should have a self-funded plan? Are there criteria?
There definitely are, and I think that is way beyond the scope of what we could speak to. That is an individualized decision based on the leadership of that practice, their CPA, their legal counsel. That's a pretty in-depth analysis that you want to undertake.
Okay, great. Yeah, that's where you get your huddle around you and talk together. All right.
Exactly. Yep.
Okay, great. A quick question about PAs. If we employ PAs and we don't want to change what we allow them to do, can we create a collaboration agreement to mirror our old supervisory agreement?
Yes, 100%. So that is one of the great things about this is you can give your PAs more freedom, but that collaboration agreement and the collaboration process that you articulate is really where you can just mirror exactly what you were doing before. You don't have to change. So one of the ways I think about this is the state getting out of your way. And if the state's getting out of your way, they're not going to mandate that you have to give them more. They're just going to get rid of their mandates. So you're free to simply mirror exactly the same relationship you have and keep that going.
Awesome. Thank you both. Thank you for sharing your expertise. Like I mentioned, I will send you the full list of questions so that you can reach out. And then for all of our attendees, if you would like to still submit a question, please send that to me at info@jrcpa.com, and I'll make sure to get it to Jaclyn and Ed. A big thank you to all of our physicians and practice administrators who joined us today. We do these webinars to be an educational resource, so we really hope that you found it helpful and useful today. And again, thanks to Jaclyn and Ed for spending time with us. We really appreciate it. Take care, everyone. Have a great weekend. Bye.